Second, considering the fact that the present petition has been filed more than 7 years after the dismissal of the SLP filed by the state against the order of acquittal claiming reinstatement which could be claimed in the years 2006, the same deserves to be dismissed on account of delay and laches only. The issue regarding delay in invoking extraordinary jurisdiction was considered by Honorable the Supreme Court in UP Jal Nigam and another versus Jaswant Singh and another 2006-11 SSC 464. It was a case in which certain employees raised the issue that they were not liable to be retired at the age of 58 years but should be permitted to continue in service till they attain the age of 60 years. They were still in service when the writ petitions were filed. The writ petitions were ultimately allowed, placing reliance upon that judgment. Some of the employees who already stood retired filed writ petitions claiming same benefit. The writ petitions were allowed by the High Court in terms of its earlier judgment. The judgment of the High Court was impugned before Honorable the Supreme Court, wherein, while referring to earlier judgments of Honorable the Supreme Court in Rope Diamonds versus Union of India 1989 to SSC 356, State of Karnataka versus SM Kotraya 1996, 6 SSC 267, Jagdish Lal versus State of Virender Singh 2014 11 04 1646. I attest to the accuracy and integrity of this document. Punjab and Haryana High Court at Chandigarh, Haryana 1997, 6 SSC 538 and Government of West Bengal versus Tarun Kumar Rai 2004, 1st SSC 347. It was opened that the persons who approach the court at a belated stage, placing reliance upon an order passed in some other case earlier, can be denied the discretionary relief on account of delay and laches. 11th paragraph thereof are extracted below. 18 in State of TN versus Sesat Kalam 2007, 10 SSC 137. This court, testing the equality clause of the bedrock of delay and laches pertaining to grant of service benefit, has ruled thus filing of representations along would not save the Virender Singh 2014 11 4 1646. I attest to the accuracy and integrity of this document. Punjab and Haryana High Court at Chandigarh. Period of limitation, delay or laches is a relevant factor for a court of law to determine the question as to whether the claim made by an applicant deserve consideration. Delay and or laches on the part of a government servant may deprive him on the benefit which had been given to others. Article 14 of the Constitution of India would not in a situation of that nature be attracted, as it is well known that law leans in favor of those who are alert and vigilant. We are absolutely conscious that in the case at hand the seniority has not been disturbed in the promotional cadre and no promotions may be unsettled. There may not be unsettlement of the settled position but a pregnant one. The respondents chose to sleep like RIP one winkle and got up from their slumber at their own leisure from some reason which is fathomable to them only. But such fathoming of reasons by oneself is not countenanced in law. Anyone who sleeps over his right is bound to suffer, as we perceive neither the tribunal nor the High Court has appreciated these aspects in proper perspective and proceeded on the base that a junior was promoted and therefore the seniors cannot be denied the promotion, remaining oblivious to the factum of delay and laches, and granting relief is contrary to all settled principles and even would not remotely attract the concept of discretion. We may hasten to add that the same may not be applicable in all circumstances where certain categories of fundamental rights are infringed, but a stale claim of getting promotional benefits definitely should not have been entertained by the tribunal and accepted by the High Court. True, it is notional promotional benefits have been granted, but the same is likely to affect the state exchequer regard being had to the fixation of pay and the pension. These aspects have not been taken into consideration. What is urged before us by the learned counsel for the respondents is that they should have been equally treated with Madhav Singh Tadgai, but equality has to be claimed at the Virender Singh 2014-11 for 1646. I attach to the accuracy and integrity of this document. Punjab and Haryana High Court at Chandigarh right juncture, and not after expiry of 2 decades. Not for nothing it has been said that everything may stop but not the time, for all are in a way slaves of time. There may not be any provision providing for limitation, but a grievance relating to promotion cannot be given a new lease of life at any point of time. In state of MP and other etc. versus Nandlal Jaiswal and other etc. AIR 1987 SC 251, the court observed that it is well settled that power of the High Court to issue an appropriate writ under Article 226 of the Constitution is discretionary, and the High Court in exercise of its discretion does not ordinarily assist the tardy and the indolent, or the acquiescent and the lethargic. It has been further stated therein that if there is inordinate delay on the part of the petitioner in filing a petition and such delay is not satisfactorily explained, the High Court may decline to intervene and grant relief in the exercise of its writ jurisdiction. Emphasis was laid on the principle of delay and laches stating that resort to the extraordinary remedy under the writ jurisdiction at a belated stage is likely to cause confusion and public inconvenience, and Virender Singh 2014-11 for 1646 I attached to the accuracy and integrity of this document. Punjab and Haryana High Court at Chandigarh bring in Justice